When it comes to workers' comp law firms, it's clear those commercials we see everywhere, including right here on Fox 24, are geared toward you, the plaintiff. Well, joining us is Adam Greene, attorney with Steinberg Law Firm, who has worked on the other side. So now you're working on behalf of the plaintiff, and what you've done is not terribly uncommon, but tell us about the transition and why you decided to transition.
Sure. So I represented insurance companies for about 4.5 years before making the switch to doing plaintiff's work. The work is different. It's probably more rewarding, but both sides come with their the rewards and challenges.
And why did you decide to make the change?
For various reasons. I think the number one reason would be how much more rewarding it is to have a human being for a client as opposed to an insurance company. But like I said earlier, it does come with its challenges. You're dealing more with emotion rather than financial bottom lines. But having that ability to represent a human being and make a material difference in their life was important to me.
Yeah, and what would you say are some of the key takeaways from switching sides that you use in your work now on a daily basis?
So I have an insider's perspective in knowing how insurance companies value cases, how they look at stuff, and how they plan to move forward with maybe their discovery plan. And I now use that in my practice to anticipate what their next move will be. For instance, I know we spoke earlier about potential surveillance. If an insurance company believes that somebody's not as injured as they are quote unquote letting on, they may put a private investigator on them for a day or two. I can anticipate when that might happen and then forewarn my client to be prepared for somebody to be watching and filming them.
And when we talk about that, would be considered part of discovery,
correct?
Right. So in other discovery, coming from the insurance side, I would imagine that you would know maybe what to hold close to your vest until it's asked for, if it's ever asked for. So now you know what to ask for that could be of benefit to your client.
Correct. So for instance, if a case is getting near the point where the parties can discuss resolution, the insurance company might get a medical cost projection from a company, and in doing so, they don't have to alert any of the parties, but I can send a subpoena to get that information ahead of time to know what cards they're holding, so I can better assess our strategy.
And what about when it comes to the actual reward? Because you know how much an insurance company would be willing to pay, so you essentially come in with the knowledge of value of someone's injury.
That has been a curse and a blessing. When I send out a settlement demand, which is the opening number to kick off negotiations, usually they're a little high, but at the same time, I try to value it as I would have as a defense lawyer. And sometimes when they don't come in with offers up to that number, it can be a little discouraging if I would have valued it a certain way and this defense lawyer is not valuing it a certain way. But it certainly helps to have insider perspective as to how defense lawyers value cases.
Yeah, and how long have you been doing this?
About 5.5 years now.
Okay, and can you tell us some of the success stories?
Sure. On the defense side or the plaintiff side?
On the plaintiff side.
That's right. We recently had a pretty involved case. It was denied from the get-go. In workers' comp, there are certain defenses that the employer and insurance carrier can raise. One was an idiopathic defense, meaning somebody fell because of an internal breakdown in their own bodily system, such as a weak knee. We were able to take that case to a hearing and get a favorable result, and then ultimately a good settlement out of that one.
Oh, well, very good. Okay, so to know that there's always light at the end of the tunnel.
There is, usually.
You just have to have the right brains on the case.
Usually, that would be, that's the goal. Hopefully we wouldn't take on a case that didn't have at least a viable path forward.
Right, and of course that's a case-by-case basis.
Correct.
And plaintiff-by-plaintiff basis.
Correct.
All right, I want to thank you, Adam, for joining us.
Thank you so much for having me.
We're back after this.